Hi, everyone, and welcome to today's Privacy Espresso. I'm your host, Siyanna, a data protection and IP lawyer from Timelex. Today, I'm joined by Mike Swift, who is a Chief Global Digital Risk Correspondent for MLex. He has been at the forefront of covering data, privacy, and cybersecurity regulatory news for more than a decade. He has covered the likes of Google, Facebook, Apple, and Microsoft, and closely tracks technology and regulatory trends in Silicon Valley. Today with him, we're going to talk about the latest development in US AI litigation. And before we dive into the topic, I want to ask you very quickly, Mike, can you start by giving our listeners a brief overview of US class action litigation? How does it work exactly?
Sure, and thanks for having me, Sienna. It's great to speak with you this morning. Class action litigation in the United States is kind of a cultural bedrock. It's something that even non-lawyers are quite familiar with. Typically, it takes place in the federal court system of the United States. It lasts for many years, and it's a way for large groups of people to get represented over a single legal question. And so that's what we're seeing now with the beginning of these suits involving artificial intelligence companies.
Okay. So which AI companies have gotten sued in the US, and what are the several main claims that are being made?
Sure. So we basically, at the end of last year, ChatGPT sort of erupted into the public consciousness. And it was right around that time that litigation started to be filed. And right now we have about 10 major class action suits, which are in the courts. Most of them are in the San Francisco Bay Area, although there's a large suit that was filed by a group of fiction writers, very prominent fiction writers, including George R.R. Martin and Scott Turow and Ellen Hildebrand against OpenAI in New York last week. But we're really seeing two overriding claims. One is copyright, that these large language models have effectively ingested the copyrighted works of many authors and other creators, and then are basically using those without compensation to create competing products for those creators. But we're also seeing almost half of these suits have privacy components to them, where there's an allegation that the AI companies have illegally appropriated personal data and are violating laws such as the California Privacy Rights Act in doing so. So it really looks like the battleground is going to be over privacy and over copyright in AI.
Okay, interesting. And could you tell us at what stage of the litigation these cases are, and can we expect when they might be resolved?
Sure. So, as I said, class action litigation typically spans years, and there are kind of four major signposts. And the first is motions to dismiss, where at an early stage of the litigation, the defendant will file a motion asking a judge to find that even if the factual allegations are true, that the plaintiff lacks standing to sue, or it's failed to properly allege a claim. And that's sort of the first place that you can knock out a class action claim. And that's what's happening right now. Most of these suits were, the first suit was really filed last November, but most of the suits have been filed only since the month of June of this year. And so we're just getting into that initial round of the litigation where we're seeing, initial motions to dismiss. We only have one ruling so far. That's by a federal judge named John Tiger in Oakland, California. And that's in a suit against Microsoft and OpenAI. And the judge did grant the motion to dismiss in large part, but it wasn't a conclusive finding because he granted the plaintiffs leave to amend their claims. And so that's something that typically happens in U.S. litigation. And we're getting set for a second round on that case for the motion to dismiss. So we're still very early on, although some of the class action attorneys I've spoken to believe that as slow as litigation is in the United States, it still could really put the guardrails around what AI companies can and can't do more quickly than the notoriously slow United States Congress will. So that remains to be seen, but we'll be watching that in the next few months and years.
Okay, interesting. So the hope is in the courts. And do you see any parallels with early US AI class action litigation over early computing technologies? Because we're seeing kind of the same trends again. So what are these?
Yeah, that's an interesting question. There are a lot of parallels. The first being that, I mean, really the last big battle was over the smartphone, right? And who owned apps, who owned operating systems. The fight between Apple and Samsung over whether Samsung copied the iPhone, and you're seeing a lot of interesting parallels already, I think, with some of the early AI suits. First parallel is that a lot of these cases are going to be fought right here in the San Francisco Bay Area, where I am, in the federal courts here. Not exclusively. I mean, the Authors Guild suit I mentioned earlier was filed in New York City, so that may happen. That is likely to stay in New York, I think. But many of these other suits against Microsoft, Google, Meta Platforms, OpenAI, they've all been filed here in the San Francisco Bay Area and are probably going to play out here. Many of the same lawyers who were involved in those earlier disputes over copyright, antitrust, patents in smartphones are actually part of these suits as well, defending companies like Microsoft, Google, and Meta and OpenAI. And so those are all really interesting kind of key parallels, I think. And it's sort of deja vu all over again, as as they like to say.
Yeah. No, that's true. And especially with regards to copyright, we have the Google book case that's being mentioned again and again. And it's definitely whatever the courts decide is going to be extremely important for the future of the technology. Thanks a lot, Mike. I think this has been very informative. It's been a pleasure to hear some insights from Silicon Valley. And I think here we can wrap up because I think we're close on time. But again, thanks a lot.
Thanks, Sienna. This was really fun.